It is good that most people will never have their daily lives disrupted by a serious crime. However, the few who do often find themselves unfamiliar with the nuances of the legal system. That can frustrate and confuse victims. It can have the same effect on everyday citizens who are simply trying to understand the procedures in a high-profile case. Welcome. My name is Jeff Kidd, and I'm the Administrative Chief of Staff at the 14th Circuit Solicitor's Office. We bring to you this video series to explain the criminal justice process in the 14th Circuit and to make the confusing clear. In this sixth episode, we explain the purpose of preliminary hearings. Those facing charges in General Sessions Court have the right to a preliminary hearing during which they can challenge whether law enforcement established probable cause for the arrest. The defendant must request the hearing within 10 days of being notified of this right, though the hearing itself might take place later than that. Often, defendants will defer the right or waive this right altogether. Preliminary hearings take place in front of a magistrate with no jury present. The accused isn't required to attend and is not allowed to testify or present evidence if he or she does. Rather, the state calls a witness or witnesses, typically an arresting officer or the chief investigating officer, to testify to probable cause. A defense attorney can cross-examine the witnesses, but questions are limited to issues related to probable cause. The judge then reviews the testimony and decides whether probable cause exists. If it does, the case is bound over for trial. If it does not, the judge dismisses the charge. These hearings sometimes take place in front of the very magistrates who determined probable cause existed when they signed the arrest warrant. In fact, in some instances and in some jurisdictions, the arresting law enforcement agency handles preliminary hearings on their own without a prosecutor present. Even if the judge dismisses a charge at the preliminary hearing, the solicitor's office can essentially reinstate it by presenting it to the grand jury for a direct indictment. In the next video, we will explain the function of that grand jury.